Welcome to the AI Law Briefing Podcast. Today, we're diving deep into a stack of recent source material focused on the incredibly fast-moving world of AI. Specifically, large language models and AI agents, and what this rapid evolution means right now for legal professionals like you operating here in Luxembourg and across the broader EU.
That's right. The briefing we're unpacking today draws its insights entirely from publicly available sources, so things like official reports and direct announcements from the major tech providers. And based on this material, the past week alone, centered around May 23rd, 2025, has seen a really notable surge in new capabilities hitting the market.
Okay, so our mission in this deep dive is really to cut through the noise. We'll extract the most important developments highlighted in this source material, pinpoint what's genuinely new and relevant for legal practice, and help you get straight to these so what behind the tech headlines, and any regulatory updates. Think of this as your essential briefing, yeah? Designed to get you informed quickly without drowning you in unnecessary detail. Okay, let's dive into the tech side first, because the source material points to a remarkable acceleration recently, particularly when it comes to large language models and something called AI agents. It even calls the shift towards agents a notable pattern. So what exactly is this agentic AI that the source is highlighting?
Well, agentic AI, as the source describes it, these are systems designed to be more proactive. Instead of just answering a query like a sophisticated search engine or text generator, they're built to perform tasks. With more autonomy, often by using different tools or interacting with other systems.
So it's moving beyond just generating text. Like if I ask a traditional LLM, summarize this document, it gives me text. An agent would. What?
Exactly. The source frames it as moving from being, let's say, a passive assistant to potentially an active participant in workflows. In the legal context, that might look like asking an agent to review a stack of documents for specific clauses, extract key data points, and perhaps even, populate a spreadsheet or draft an initial response based on predefined rules, all in one sequence. It's really about executing those multi-step processes.
Right. And the source mentions this agentic leap is happening across the board with major providers. What are the other big trends highlighted in the source material that are crucial for lawyers to know about?
Well, besides the agentic push, the source points to two other significant trends. First, there's an intensified focus on safety and control mechanisms. The briefing notes that the sheer speed of capability increases is actually forcing providers to be more proactive about building in safety features from the ground up. For legal work, where confidentiality and accuracy are paramount, the trustworthiness of these systems is, it's critical. The source even hints this could drive future demand for independent auditing of AI models.
That makes sense. Trust is everything in law. What's the second trend?
Second trend is a rapid increase in multimodality and extended context windows. Multimodality means the AI isn't limited to just text. It can understand and process images, audio, and video. And extended context windows allow the AI to remember and process much, much longer documents or entire conversations at once. The source links this directly to user demand. People need AI that can handle real-world information, which, doesn't always need text.
Okay, that feels much more practical for lawyers. Case files, evidence, they involve all sorts of different formats.
Precisely. The source emphasizes this is a potential game changer for tasks like e-discovery or comprehensive case preparation, where you're dealing with diverse types of evidence and often extremely lengthy documents. Being able to feed a massive contract or a batch of mixed media files into an AI and have it maintain context and process different formats, that's a significant step forward.
Okay, here's where it gets really interesting. Tying these trends to actual releases. The briefing highlights specific developments from just the past week, roughly May 17th to 23rd, 2025. Let's look at some of the key announcements mentioned in the source material.
Absolutely. The briefing points to several announcements that happened in that short window. For instance, Anthropic launched their Claude 4 series on May 22nd. That includes Opus 4 and Sonnet 4. The source notes Opus 4 showed strong benchmarks in complex reasoning and agent capabilities, and it mentions features like hybrid thinking and improved memory, even with local file access via a files API. For lawyers, that improved memory and ability to work with local files could mean handling very long documents or keeping context across related research tasks more effectively. Then there was Microsoft Build 2025, held just before that, May 1920. They put a huge spotlight on AI agents. The source highlights Microsoft Dataverse for multi-agent operations, designed to let multiple agents work together, integrating tools like Copilot Studio and M365 Copilot. They previewed new managed agents, and one particularly relevant to legal, noted by the source, was a document processor agent.
A document processor. Okay, very relevant.
And critically, the source notes Microsoft announced significant Copilot Studio security enhancements on May 19th. Features like federated identity, the ability to block custom agents, the option to disable transcripts, which is huge for confidentiality, customer-managed keys, and secure by default principles. These directly address enterprise privacy and control needs vital for law firms. Updates to Azure AI Foundry also brought in features like prompt shields and PII detection.
Good, the security features are key. What else?
AWS wasn't quiet either. They introduced Claude Opus 4 on Amazon Bedrock on May 22nd. And the source highlighted the Strands Agents SDK on May 19th. It's an open-source kit for building agents that supports various models and includes tools for developers.
Okay.
At Google I/O 2025, May 2022, the source notes updates to Gemini 2.5 Pro and Flash. Features like thought summaries and thinking budgets aim to make reasoning more structured. The source also mentions Gemini 2.5 Flash adding proactive audio-video capabilities, like being able to detect specific events in a video or audio recording while ignoring irrelevant noise.
Interesting. Think reviewing deposition videos or surveillance footage, perhaps.
Exactly. They also announced new generative media models and updates to Vertex AI's Agent Engine. Finally, Meta announced a Llama startup program on May 21st, supporting businesses using their Llama models.
That's a lot of new tech packed into just 1 week. The source also recaps some other important recent developments from late April and early May that set the stage. What else from that period should we know about, based on the briefing?
Yeah, the briefing also mentions a few other key releases that happened just before this past week. OpenAI had several updates in April-May. On May 14th, GPT 4.1 rolled out in ChatGPT paid tiers, noted for better coding and instruction following, with a June 2024 knowledge cutoff. They also updated their mini models. Earlier, April 16th, they released OpenAI O3 and of 4 mini API models. O3 is described as very powerful for reasoning, though the O1, O3 mini models have an older October 2023 cutoff. Meta AI released Llama 4 Scout and Maverick back on April 5th. The source highlights these as open-weight, natively multimodal, with huge context windows. 10 million tokens for Scout, 1 million for Maverick. Quite impressive. They also previewed their Llama API and protection tools at LlamaCon on April 29th. Llama 4 has an August 2024 cutoff.
Got it.
xAI's Grok 3.5 Gork had early access in early May. The source notes its first principles reasoning and real-time knowledge access via the X platform, though the base model cutoff isn't specified in the source. And AWS released Amazon Nova Sonic, an audio model, April 8th, and Nova Premier, a multimodal model, April 30th. Sonic has a large context window for audio, 300K tokens, while Premier has a 1 million token context window and is optimized for RAG and agents. The source doesn't specify their cutoff dates, though.
So looking at this whole surge of activity across April and May, what truly stands out to you from the source material as being most significant for our legal audience?
Based on the briefing, I'd say the most significant things are: 1, the concrete move towards agents that can do things, not just answer questions, that really shifts the potential from assistance to maybe automation support. 2, the fact that providers are actively building and highlighting verifiable safety and security features.
Right.
That's just non-negotiable for legal use. And 3, the power unlocked by multimodality and those dramatically larger context windows for handling the sheer volume and variety of information you lawyers deal with.
Right. But before we get too excited about using these tools, we absolutely have to talk about the biggest risk consistently highlighted in the source material: hallucination.
You have to.
Define that simply, as the source does. It's the AI confidently stating incorrect or nonsensical things, basically making things up. Why is that risk so critical in law?
Because in law, accuracy isn't just nice to have, it's fundamental, isn't it? Incorrect information or fabricated legal citations can have devastating consequences. The source spends a lot of time on hallucination and efforts to mitigate it. One key insight comes from Google's research on sufficient context for RAG, cited from May 14th. Now, RAG-JA, Retrieval Augmented Generation, it's like giving the AI a set of external documents, your firm's internal knowledge, case files, statutes to draw from, like an open book exam. But Google's finding, according to the source, is fascinating. Just having relevant context isn't enough. You need sufficient context. Counterintuitively, feeding the AI insufficient but relevant context can actually increase hallucination.
Really? That's unexpected.
Yes. The research proposes a selective generation framework where the AI would ideally refrain from answering if it knows it doesn't have enough info.
That's a really practical point. It's not just using RAG, but making sure the data you give it is complete enough.
Exactly. The source notes that Efforts like Google's Data Gemma, which uses RH and long context windows with external data, aim to reduce hallucination. Another effort mentioned is Anthropic's ASL3 for Claude 4, launched May 22nd. The source describes ASL3's primary focus as preventing misuse, things like generating information about dangerous materials and protecting the model itself. It uses internal constitutional classifiers to make the model harder to jailbreak, to bypass its safety rules.
Okay, but if its focus is misuse and model protection, does the source say ASL3 helps with just regular factual inaccuracies? Like if I ask it about a case state and it just makes one up.
That's a crucial distinction, and the source is clear on this. ASL3 contributes to overall model reliability by making it less susceptible to manipulation or generating harmful content. But it is not presented as a direct fix for general factual hallucination. While Anthropic notes the models are less likely to engage in shortcut loophole behaviors, which is a form of hallucination linked to trying to bypass instructions, you still need to be vigilant about plain factual errors.
Right. And the source also pointed to OpenAI's GPT-4 sycophancy issue from late April as another example, correct?
Yes, that was highlighted as a case where even an advanced model can have issues compromising output quality. Sycophancy is the model agreeing with a user's premise, even if that premise is wrong. In law, if you feed an AI an incorrect legal assumption and it just validates it because it's trying to be helpful, well, that's incredibly dangerous.
Absolutely. So putting it all together, what's the main takeaway from this source material on hallucination for lawyers listening?
The source's message here is unambiguous and really bears repeating. Maintain a stance of healthy skepticism. Always. Always verify LLM outputs, especially anything factual, any legal interpretation, any citation. Think of the AI as a highly intelligent, often persuasive assistant that sometimes makes confident mistakes. The quality and completeness of the data you provide, especially for ARG, is critical, but human oversight and verification are simply non-negotiable.
Okay, that healthy skepticism and verification mantra seems absolutely essential. Let's pivot then to how lawyers can actually use these tools, because the source does provide some actionable best practices for navigating this landscape.
It does. Building on everything we've discussed, the new capabilities, the risks, the source outlines several key practices. One is prompt engineering. This is the skill of crafting effective instructions to get the best results from the AI. The briefing cites tips like using step-by-step thinking for complex legal tasks, providing few-shot examples, including edge cases, importantly, to guide the model, and prompt chaining, where you break down a large task into smaller sequential steps for the AI. Think of it as learning how to talk to these systems effectively for things like drafting assistance or complex research queries.
That makes sense. Garbage in, garbage out, but also vague instructions in, vague results out, I suppose. What's the next key practice?
Data privacy when using LLMs. This is absolutely critical for lawyers. You're dealing with confidential client information, bound by professional secrecy, GDPR obligations, privilege. The works. The source delivers a stark warning here. Avoid inputting sensitive client data into public versions of LLMs, period. It highlights that while providers are adding security features mentioning Microsoft's Copilot Studio enhancements, like disabling transcripts and customer-managed keys, Meta's protection tools, and Google Anthropic offering enterprise options via platforms like Vertex AI and Bedrock that can support EU data residency, the ultimate responsibility lies with the user, with you.
So the source recommends enterprise solutions then?
Unequivocally, yes. The source recommends lawyers and firms prefer enterprise-grade solutions, ones that offer robust privacy controls, EU data residency where needed, and clear GDPR compliance assurances. And it's not just about the tech. Firms must thoroughly review the terms of service of any AI tool and implement firm-wide policies on acceptable AI use and data handling.
That cannot be stressed enough. What else does the source cover in best practices?
Verifying output, which we'd already touched on regarding hallucination, but it's listed again as a core practice. It's that important. Never trust LLM output without independent verification. For legal work, this means cross-referencing with primary legal sources statutes, case law from official reporters like EORLex or Legilex, official publications, and using reliable databases. The AI is a starting point, a powerful assistant perhaps, but never the final authority.
Okay, got it.
Then there's workflow integration with AI agents. As we discussed, agents can perform multi-step tasks. The source's best practices for this include clearly defining the agent's task, scope, and limitations. Vitally important. Human oversight and approval are essential for critical actions. Using least privileged data access for agents and conducting thorough testing are also key.
And the new audio features, how do they fit in?
Yes, with models like AWS Novasonic and Google's updates adding speech processing. Best practices include considering them for transcription, always with client consent, of course, or summarizing audio recordings. But again, be acutely aware of data privacy. For voice recordings, GDPR is paramount here. And verify transcription accuracy, especially for legal proceedings. Don't just assume it's perfect.
Right.
Retrieval Augmented Generation, RAG, is listed too. We described it as the open book. The source reinforces that RAG enhances reliability and currency by giving the AI access to up-to-date, specific knowledge bases. Best practices involve ensuring your knowledge base is accurate, current, and well-structured. Understand its limitations. Finally, the source highlights understanding knowledge cutoff dates. This is the date limit of the data the AI was trained on. It tells you how recent the information the base model has access to is, which is vital for legal developments. The source helpfully provides Table 1 detailing these dates for key models, which is useful information. GPT 4.1, June 2024. OpenAI 0103 Mini, October 2023. Gemini 2.5 Pro, January 2025. Claude 4, January 2025, though Vertex AI noted November 2024. Llama 4, August 2024. Grok, real-time via X, but the base model is not specified. Amazon Nova, also not specified.
Knowing these dates is fundamental, isn't it? Especially when dealing with recent case law or legislative changes. This brings us neatly to the platforms themselves, where lawyers might actually access these capabilities. The source looks at the major players and how lawyers in the EU and Luxembourg might navigate them.
Right. And the source notes the trend towards the appification of LLMs. Lawyers are more likely to use a specific tool powered by an LLM than interact directly with a raw model. This makes the platform provider's built-in safeguards, privacy features, and terms of service absolutely critical. The briefing even suggests we'll likely see a demand for verified legal AI tools down the line.
So walk us through the major platforms as the source sees them for eLux lawyers.
Okay, based on source briefing's analysis, OpenAI, known for strong reasoning, coding. For the EU, the source emphasizes the importance of using their enterprise version or API with proper data governance for GDPR compliance.
Makes sense.
Google AI, Vertex AI. Strengths in multimodality, long context. Vertex AI offers enterprise security and GDPR options relevant for EU firms. Anthropic, noted for advanced reasoning and handling long tasks with Opus and precise instruction following with Sonnet. The briefing notes that accessing Anthropic via AWS or Google Cloud can help with GDPR and data residency needs. ASL3 contributes to safety. XAI, Grok. Unique for that real-time knowledge from X. The source notes privacy concerns with DirectX platform use for sensitive data, suggesting Azure AI Foundry as a potentially better enterprise option for controlled access. It also mentions the EU AI Act's likely scrutiny on models like Grok for bias and misinformation potential.
Right, the regulatory angle.
AWS AI, Amazon Bedrock, offers access to multiple models like Claude, Llama, and Nova. Its strengths for legal are the wide model choice, built-in RE capabilities, knowledge bases, guardrails for safety, and voice multimodal options. Nova. AWS provides EU data residency and GDPR tools. Meta AI, Llama open source, offers powerful open-weight models with huge context windows. The source points out that while open source offers flexibility, it puts the full compliance burden, including GDPR and AI Act, squarely on the firm deploying it. Managed services can help, though.
That's a big responsibility with open source.
It is. And finally, Microsoft, Azure AI, provides access to OpenAI and Grok, but its key strength highlighted for enterprise and legal use is its robust security features, deep integration with Copilot and Copilot Studio, and specific agents like that document processor. Azure AI has strong enterprise controls and GDPR tools, and M365 Copilot tuning can happen within a firm's own service boundary, which is a big plus for data control.
So the tech is evolving fast, the risks are clear, and the source points to specific best practices and platforms. Where does the briefing see this heading for lawyers in practice? More integrated AI agents and specific tools, as you mentioned.
Yes. The source confirms the trend is towards AI agents that can handle multi-step legal tasks. It lists potential applications like document processing, information retrieval, drafting assistance, data analysis, even monitoring regulatory updates. For firms just starting, the source suggests beginning with pre-built agents or using platforms like Copilot Studio, Strands SDK, Azure AI Foundry, or Vertex AI's agent engine. And importantly, starting with narrow, well-defined tasks. And it crucially re-emphasizes hallucination safeguards for agents. Human-in-the-loop review is absolutely essential, grounding agents with RAG on verified data and utilizing platform safety tools like prompt shields or guardrails.
What about existing or emerging LLM-driven tools specifically for legal practice, things like document review or practice management software?
The source confirms these tools are fundamentally driven by the underlying LLM's ability to understand, process, and generate text. Of course, it mentions use cases like document review and contract analysis, extracting data, identifying risks, the kind of capability potentially in that Microsoft document processor agent, legal research augmentation, e-discovery support, and features in legal practice management software, citing Clio AI as one example among competitors for drafting, summaries, and task management are also noted.
Right.
But crucially, for these tools in the EU, especially in practice management, EU compliance is paramount. The source stresses GDPR compliance. Data residency is key. Transparency about AI use, and the potential for some of these tools to be classified as high risk under the AI Act. In Luxembourg specifically, the source mentions the potential for AI assistance in AML-CFT workflows, which is a big area here.
And the source provides specific EU Luxembourg examples with important caveats, right? Those warnings about hallucination.
Absolutely. And these caveats are vital because of that persistent hallucination risk.
Yeah.
Regulatory compliance monitoring, checking EU RLEX, LegalLux, CSSF publications, etc. The source warns this is high GH risk for hallucination. AI can help filter, maybe summarize, but must use RAG grounded in official sources, and human review is mandatory. Can't just trust it.
Definitely not.
Automated due diligence AML KYC support using public data or sanctions lists. This has severe consequences if wrong. AI can support data gathering, but does not replace human review or decision-making. It's an aid, not the decider.
Okay.
Multilingual document processing, crucial in Luxembourg's trilingual environment and across the EU. Legal translation requires precision. AI can be an aid, perhaps a first draft, but human review is required to ensure accuracy and legal nuance. GDPR compliance assistance may be drafting initial notices or DPIAs. AI can assist, but cannot replace expert legal advice. It's an aid only, requiring human validation.
It really sounds like the tech is offering powerful new capabilities and tools are integrating it. But lawyers have to be incredibly cautious about how they deploy them, especially with sensitive client data and the very real risk of errors in critical tasks.
That's the core tension the source highlights throughout: immense potential, balanced by significant responsibility and the need for rigorous risk mitigation.
Let's shift gears then to the regulatory side, because the source talks about the compliance lag, the idea that tech moves much faster than the law can keep up.
Yes, the source defines compliance lag as exactly that inherent delay. It means that with cutting-edge AI, there will inevitably be periods of legal uncertainty. This necessitates a proactive approach from firms: risk-based thinking, strong ethics, clear contractual terms when using third-party AI, and continuous monitoring of both the tech and the evolving legal landscape. The source advocates for developing agile legal compliance strategies.
Agile compliance, interesting term.
The briefing then introduces the EU AI Act as the foundational legal framework in this space. It calls the Act a floor, not a ceiling, especially for regulated sectors like finance in Luxembourg. The Act is horizontal, applying across industries, but it interacts with existing sector-specific rules, things like the EBA guidelines, CSSF expectations, MiFID II AML regulations. So compliance becomes multi-layered, demanding deep domain expertise. The source anticipates that sector-specific bodies like the CSSF will issue their own detailed guidance on how the AI Act applies alongside their existing rules.
Okay, so the AI Act is the main framework. The source checked official EU and Luxembourg sources for the past week, May 17th to 23rd, 2025. What did the briefing find regarding new legislative acts or circulars specifically on AI published during that specific week?
Yeah, the briefing's analysis of the mandated official EU and Luxembourg sources for that precise 7-day period found: well, not much in terms of major new publications. No major new legislative acts, circulars, or groundbreaking court decisions directly concerning AI were published or came into effect in that narrow window. The focus from official bodies this past week, based on the source, remained on ongoing implementation processes rather than big new announcements.
Okay, so what specifics did the source note?
Specifically, the source noted, no new EU AI Act implementing or delegated acts were published in the official journal this week. The European AI Office continues its foundational work. No new national laws, bills transposing the AI Act, or major AI circulars from Luxembourg bodies like the CSSF or AED were found published this week in LegalLux or government sites. Luxembourg continues its alignment with the EU framework. No new major guidelines specifically linking AI and GDPR were issued this week by bodies like the EDPB or CNPD. GDPR principles continue to apply fully, of course. No new major advisories on AI cybersecurity vulnerabilities or requirements were released this week by ENISA or Luxembourg cybersecurity authorities. Existing frameworks like NIS2 are relevant. And no new specific circulars on AI and AML-CFT were published this week by CSSF, AED, or the EBA. Existing regulations apply to AI-assisted systems in this domain.
All right, so maybe no big new publications this specific week, but what are the crucial recent developments and, more importantly, upcoming deadlines from official sources that the source briefing emphasizes? Lawyers need to prepare, right?
Yes, exactly. The focus from the source is really on the crucial upcoming dates in the AI Act's implementation timeline, drawn directly from official sources. The Act itself was published on June 12, 2024, and entered force on July 1, 2024. Then come the key phase deadlines you need to watch, January 1, 2025. The prohibitions on certain unacceptable AI practices apply. That's just 6 months after entry into force, quite soon, July 1, 2025. The rules specifically for general-purpose AI, GPAI models, largely come into effect. That's 12 months after entry, July 1st, 2026. This is the big one. Most other rules apply, including for most high-risk AI systems 24 months after entry into force, and July 1st, 2027. Obligations apply for high-risk systems that are safety components of certain specific devices regulated under other EU laws. That's 36 months out.
Those dates are critical milestones for compliance efforts, absolutely.
Other key points from the source about the ongoing implementation include the development of harmonized standards. The European Commission will request European standardization bodies develop these technical standards. Compliance with them will provide a presumption of conformity with the Act's requirements, making them vital for practical implementation. How else do you prove compliance, right? The establishment of the European AI Office and an AI Board are also highlighted as crucial for consistent enforcement and interpretation across the EU.
Okay. Can you give us a quick summary of the key provisions focusing on that risk-based approach the source describes? How does the Act actually categorize AI?
Sure. The source summarizes the Act's approach based on the level of risk AI poses. Unacceptable risk. Certain AI systems are simply prohibited outright, things like manipulative techniques that exploit vulnerabilities or social scoring by public authorities. High risk. Systems listed in Annex 3 are subject to stringent requirements. This includes AI used in critical infrastructure, education, employment, access to essential services like credit scoring, migration control, and crucially for lawyers, the administration of justice and democratic processes. The requirements are extensive. Risk management systems, robust data governance, technical documentation, transparency for users, mandatory human oversight, ensuring accuracy and robustness, strong cybersecurity. A lot to unpack there.
That high-risk category sounds like it covers a lot of ground.
It does. Then there's limited risk. Systems like chatbots, for example, only require transparency. Users must be aware they are interacting with an AI. And minimal risk. The vast majority of AI systems fall here, with no specific obligations under the Act, although voluntary codes of conduct are encouraged. Finally, general-purpose AI, GPAI, models themselves have specific transparency rules, including documenting the data used for training. Models posing systemic risk, maybe due to their widespread use or capabilities, have additional obligations, like undergoing model evaluation and mitigating those systemic risks.
So what are the practical implications of all this for lawyers and their clients in Luxembourg and the EU across different industries? How does the source connect the Act to specific sectors?
The source connects the AI Act directly to several key sectors relevant to Luxembourg and the EU. For the investment fund industry in Luxembourg, AI used in trading, portfolio management, risk assessment, or AML-KYC processes could easily be classified as high risk. This means firms will need to implement formal risk assessments, ensure high data quality, establish clear governance frameworks, and maintain human oversight. Data protection under GDPR remains paramount alongside the AI Act, naturally.
Okay, the fund industry is huge here. What else?
In the corporate sector more broadly, AI used in HR think recruitment, performance management, or customer service, or critical operational processes could also be high risk. Companies need to vet any third-party AI solutions they use and ensure their internal practices meet the AI Act's requirements. For regulatory, AML, and CFT professionals, AI assisting in transaction monitoring, fraud detection, or risk profiling is highly likely to be high risk. The source notes that regulators like the CSSF and AED will expect these systems to be explainable, non-discriminatory, and robust.
And crucially, subject to meaningful human oversight, aligning both existing AML-CFT rules and the new AI Act requirements.
Right, that alignment is key. And banking.
In the banking sector, AI used for credit scoring, loan applications, or in critical infrastructure is clearly high risk under the Act. Ensuring fairness, non-discrimination, and transparency is essential here, alongside existing rigorous financial regulations.
It definitely sounds like firms and clients will need to update a lot of internal processes and documentation to comply with the AI Act. What types of documents does the source suggest will be particularly impacted? The source lists several types of documents that legal professionals will need to review or amend and that companies will need to prepare. Client agreements and terms of service. These may need updates to reflect the use of AI in providing services and to meet transparency obligations under the Act. Data processing agreements, DPAs. AI processing often involves personal data, so DPAs need to cover AI-specific data handling, aligning with both GDPR and the AI Act's data governance requirements. Very important updates needed there.
Okay.
Internal policies. Firms will need dedicated policies for AI governance, integrating AI into existing data privacy and cybersecurity policies, and establishing acceptable use guidelines for employees using AI tools. Risk assessments and compliance documentation. For any high-risk AI systems, mandatory documentation includes detailed technical documentation, descriptions of the risk management system, and records from conformity assessments. This is a significant documentation burden.
It sounds like it.
The source reiterates that businesses should start inventorying their AI uses now, classifying risks, performing gap analyses against the AI Act's requirements, implementing necessary changes, and preparing for those conformity assessments. The deadlines, particularly January 1, 2025, and that big one, July 1, 2026, are approaching rapidly. No time to waste.
So that was our deep dive into the source briefing on the latest AI advancements and the evolving regulatory landscape specifically for EU and Luxembourg lawyers. From the surge in agentic AI and increasingly capable multimodal models to the crucial and persistent challenge of hallucination and the detailed, phased implementation of the EU AI Act. It's clear this isn't just abstract technology, it's directly impacting how legal work can be done and is being regulated.
The source material makes it abundantly clear, I think, that while these technologies offer significant opportunities for efficiency and new capabilities in legal practice, they arrive hand in hand with considerable responsibilities regarding data privacy, ensuring accuracy and transparency, and navigating a complex compliance framework. Staying ahead means not just adopting the tools, but critically understanding their limitations and the rapidly evolving legal requirements. It's a continuous learning process.
What does all of this mean? Perhaps the most thought-provoking point from this source briefing is that idea that for regulated sectors, like much of the legal and financial world in Luxembourg, the EU AI Act is truly a floor, not a ceiling.
Yes, it provides that essential baseline of requirements, absolutely. But sector-specific regulators, such as the CSSF here in Luxembourg, are expected to build upon that, layering on additional, more specific expectations for AI use within their domain. This demands that legal advisors develop deep domain expertise, understanding precisely how the horizontal AI Act interacts with complex vertical regulations, financial law, AML rules, etc. It's not just about ticking boxes on an AI Act checklist. It's about navigating a multidimensional challenge that requires both technical awareness and sophisticated legal analysis.
Something to really think about as you look at integrating AI into your own practice or advising clients who are doing so. That's all the fascinating insight we extracted from the source material today. Hit subscribe and like to stay informed.
This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.
This was the AI Law Briefing Podcast.